And welcome to the 33rd Annual Robert Wagner Labor and Employment Law Moot Court Competition. One quick reminder, please everyone turn off your cell phones, pagers, iPods, any other type of electronic device you can think of. We definitely don't want to distract from the hard work that these competitors have put in. I would like to thank everyone for coming and welcome you to this event. This has been a very rigorous competition this year. We had 45 teams actually compete, which has been the largest that we have ever had. And I think you can ask any of the people in this room that have judged the competitors. Every single team has clearly put a lot of time, effort, and practice into trying to be the best advocates possible. And so the 4 competitors today have really accomplished something just by getting to the final round. I would also like to point out that the Moot Court Association at New York Law School is a wholly run student organization. So everything you see here today and everything that you've seen throughout this whole weekend has been done by students, especially our fact pattern. And in fact, our fact pattern has been thought of as such an excellent fact pattern that it's been borrowed by another school to use for their own competition. So I would like to congratulate our fact pattern authors, Stephen Sirota and Shane Humphreys, for that huge honor. So thank you. And at this time, I'd like to introduce my vice chair, Armando Acosta. Most of you have never seen him because he has been stuck in a room for the past 2 days of the competition doing all of the scoring. But we finally let him out, and so he's going to come and thank all of the very important people that have helped run this competition. So Armando.
I think we should start off by giving another round of applause for Michelle. She's done a great job. All right, so without taking too much of your time, I just wanted to give some thank yous that need to go out. This was a team effort. It took the effort of not only the chairs, but our association and the entire school. So first and foremost, I'd like to thank Dean Matisar and Dean Buckler for their support. From the beginning of the competition all the way through the final round bench, where you'll see Dean Matisar actually on our final round bench. We couldn't have done this without the support of the deans. So thank you, Dean Buckler, Dean Matisar. Also our faculty advisor, Professor Susan Abraham. She was intimately involved. Yes, a round of applause for Professor Abraham. I mean, she was intimately involved from the first rough draft of the fact pattern all the way to the last period was put, reaching out to the faculty, asking them to come out and help judge our rounds. So Professor Abraham, we couldn't have done this without you. We'd also like to give a special thank you to our fact pattern advisors, Professor Carlin Meyer, who's right here in the front, and Professor Margaret Leibowitz, who's not here with us today, but both of them were great tools for Shane and Steve, so thank you. To all the professors and faculty members who helped us judge during this competition, I don't want to leave any faculty members out who are in the room, but just Professor Fahey, Professor Leonard, and any other professors who are in the audience. Thank you for helping us judge the preliminary and the elimination rounds. To our association, who I see a lot of our members outside, out in the audience, we couldn't have done this without you. And I'm not only talking about the days of the competition, but from the beginning when we started planning, you guys were there to help us stuff envelopes, staple papers, reach out to the Alumni Association, timekeepers and judge escorts. You guys really do deserve a round of applause, so thank you. To all of our alumni of past New York Law School Moot Court Associations, your guidance and support and advice has really helped us through this. And finally, certainly not least, I would like to thank the Wagner chairs and authors, Shane Humphreys and Stephen Sirota, I think the fact pattern speaks for itself. It was great. You guys did a great job, and you really deserve a round of applause. So without further ado, I'd like to introduce the stars of this show, Mr. Adam Love and Ms. Jillian Cotlin.
Good afternoon, everybody. This is just a quick bit about how the competition runs. Starting Wednesday night, all of our competitors arrived and we had a nice reception for them. And then Thursday morning, we did the first 2 preliminary rounds for the 45 teams that came. Friday, we had our 3rd preliminary round for the 45 teams before our first elimination to the octo finals. Saturday was the quarterfinals and the semifinals. Last night was the lovely Wagner ball, which I think we all had a good time at, and a nice release for us all. And obviously today is the final round for the competing teams. It's a rigorous competition over 4 days, and we have great schools that come and visit us every year, and we're very happy to have them here back every year. And we also, just a quick note, which is interesting, when we were cleaning out the office this summer, we found the original Robert F. Wagner fact pattern and rules from 33 years ago. And we have it in our office, and it's just a nice reminder of what this association has built over its existence, and especially with this competition, in that it's lasted for 33 years, and we have 46 teams competing, and we're very proud of that. A quick bio of Robert F. Wagner. He was born in Germany and immigrated to the United States as a child. He graduated from City College, City University of New York, and received a law degree from here, New York Law School, in 1900. He began his career in politics in 1904 when he was elected to the New York State Assembly and then the Senate. He was Democratic floor leader for 8 years, and he was also chairman of the State Factory Investigating Commission. He investigated the tragic Triangle Shirtwaist Factory fire and other industrial standards. He also served as a justice of the New York State Supreme Court. In 1926, Senator Wagner was elected as a Democrat to the United States Senate representing New York, and he was re-elected in 1932, 38, and 44. And he served until he fell ill in 49. During his tenure as United States Senator, he served as chairman of several important committees: the Committee on Patents, Committee on Public Lands and Surveys, and the Committee on Banking and Currency. He also, and most importantly, was the author of the National Labor Relations Act, which guarantees workers' rights to organize and bargain collectively. He was also a delegate to the United Nations Monetary and Financial Conference at Bretton Woods in 1944, and he died in New York City in 1953.
Just a few brief thank yous. First, we'd like to, on top of what Armando said, obviously repeating all of his thank yous, we'd like to send a special thank you to Sally Harding, Jessica Alvarez, Jimena Butrago, and the entire staff of the Office of Alumni Relations, Brenda Olo, the Office of Public Affairs, the Audio-Visual Department, the security staff, the catering staff, and the maintenance staff. We'd also like to send a special thank you to Armando Acosta for scoring for us, making this all possible, and to Paul. We have gift certificates for both of you, but we're going to give them to you later. Also, Ms. Tonelli, without you, this wouldn't have happened. Exactly what Armando's doing with the bowing down. You saved us in certain times when we had no one else there to help us, and we greatly appreciate that. So if you can come on up here and take a... And is Sandra here? I don't see you, Sandra. Well, we got Sandra Davis, who is the moot court goddess, shall we say. A bouquet of flowers for everything that she's done for us, from dealing with Jillian and I, complaining to her that we're not getting something when we asked for it merely an hour ago, to just being there and making us laugh when we were stressed out over the weekends when we saw her. So, Sandra, if you're watching on the web, hi, we thank you. If not, I guess we'll give them to you later and they'll be sitting on your desk. So, yeah, Sandra. Next, Professor Meyer, we thank you so much for helping Shane and Steve, for putting up with them, and for helping them meet every deadline that we set that was most commonly impossible to actually meet. So these are for you on behalf of everybody here. Professor Leibowitz, too, we're not forgetting about her. We thought it was hard to give them via webcam. So these are for you, if you're watching. Last but not least, Professor Abraham, for everything that you've done. It's been said over and over again, and words can't describe how much you've done for the association. So thank you. All right, I lied last but not least. Jillian's looking about who I'm going to say right now, like she doesn't know. This is for Jillian. For putting up with me. We'll make a long story short. I feel like I've had a wife for the past 6 months that I'm now about to get divorced from. I don't know how I'm going to wake up tomorrow morning and handle it without my cell phone ringing from her or an email from her. I don't know. If anybody knows a good psychiatrist, we might need one.
Couples therapy. I also want to thank Adam, my co-chair. It was a pleasure working with him, even though we bicker like an old married couple, and I think everyone in the association can attest to that. He understands that I come by my micromanaging genetically, and I can't help it, but he was also there for me when I was in the fetal position on the couch the other night. So there's photographic evidence you don't want to know. But it's been a pleasure to work with him, and I think tomorrow we'll both have a little separation anxiety.
So without further ado, Professor Abraham is going to come up here. She's going to announce and explain the final round bench. So here she is.
Okay, I'm just going to go through some of the biographies of our stellar final round bench. We're really honored today to have a great bench, and we're going to see them in a few minutes. So I'm just going to say a few things about the background of each one. First, we have the Honorable Judge Harold Baird, Jr. He's a senior justice in the United States District Court for the Southern District of New York. He was nominated by Bill Clinton in '94. Prior to being on the Southern District, he was elected to the Supreme Court in New York, where he sat until 1992. Those of you who aren't from New York probably don't know that the Supreme Court is our lower level court, not our highest level court, but that's because we like to be really tricky in New York. Before that, he was the Executive Judicial Officer for the Judicial Arbitration and Mediation Service. Prior to serving as a judge, he was an Assistant U.S. Attorney, Chief of the Criminal Division in the Southern District, first Executive Director of the Civil Complaint Review Board of New York, and an adjunct professor at New York Law School from 1974 to 1983. We're very honored to have Judge Baird serving as our Chief Justice, I believe. Our next justice is very familiar to those of us who have the honor of working under him or with him at New York Law School. It's Dean Richard Matissar. He's a nationally recognized scholar in civil procedure and federal jurisdiction. He's the 15th Dean and President of New York Law School. He came here in the year 2000. Prior to being here, he was a professor of law at the University of Florida and was its 9th Dean in 96 to 99. He was also Dean of Chicago-Kent from 91 to 96, and he was a professor of law at the University of Iowa and Associate Dean. He's published extensively. He's much loved and much revered by those of us at the New York Law School community, and we're very honored to have him here. We're also honored to have Ronald Meisberg return to us for the second year General Counsel of the National Labor Relations Board, particularly important for this fact pattern. It's going to be very exciting to hear how he asks questions on the issue that is really deeply rooted in the National Labor Relations Act. He serves a term as general counsel since 2006 that will end in 2010. In 2004, he served as a member of the National Labor Relations Board and was a special assistant to the deputy in 2005. Prior to serving on the board, he was engaged in private practice in labor law for 23 years, most recently as a partner in Ogletree, Deakins, Nash, Smoke, and Stewart, and earlier with another firm, Heenan, Alphen, and Rolls. Moving on to our next final round justice, also really interesting, and we're very honored to have Clifford Gregory Stewart, who was general counsel for the Equal Employment Opportunity Commission under the Clinton administration from 1995 to 2001. He was appointed by Bill Clinton. So our other issue, he'll have some really special insight into that issue. After being on the EEOC, he was a partner in the Cochran law firm in Washington doing litigation. He's a trial lawyer. And now he is a partner in his own firm in Washington, D.C., where he concentrates on litigation, mediation, and arbitration. I'm especially honored to have Greg Stewart here today, as he was a law school classmate of mine, and we worked together on a book that one of our most dear faculty members was writing, Arthur Kanoy, who was much loved at Rutgers Law School. So I'm happy to welcome Greg Stewart to serve with us today. And our final round justice is Administrative Law Judge Robert Tuosto, who honors us by returning to be a judge here for Wagner. He was a great judge for our competition in the fall. The Purcell competition, he's an administrative law judge at the New York State Division of Human Rights, hearing cases alleging violations of New York State human rights law. Prior to serving on the bench, he was a sole practitioner in New York with an emphasis on litigation. We're very honored to have all of these judges on our final round bench, and hopefully now, with no further ado, we can get started.
I just want to, before we begin reading the facts, I just want to give a special thanks to Adam and Jillian. I didn't get to say so at the brunch, but you guys putting up with us, and giving us our deadlines, but always being there to support us and help us whenever we asked or needed it was really very, very, very crucial in this writing process. Without further ado, Mr. Humphreys will begin the reading of the facts.
Daniel Noonan, the petitioner, is a senior handyman, assistant superintendent in a 3-building, 600-unit residential apartment complex, Bushwood Towers. He works for Empire Property Management, a wholly owned subsidiary of Empire Property Development, the builder and owner of the complex. The complex has 61 employees, including Superintendent Ty Webb and Noonan. Webb also serves as general manager of Bushwood Towers. All employees, except for the superintendent, are members of Local 101 of the National Apartment Workers Union. Noonan was hired by Empire in June 12 of 1997 to work as a porter. His responsibilities included collecting garbage, vacuuming the hallways, mopping the floors, and generally keeping the place clean and tidy. He was also required to help the maintenance men, or handymen, as they are known in the industry, who are responsible for the mechanical upkeep of the property. They undertake maintenance and repair work, including electrical, carpentry, plumbing, mechanical and plastering work. The handymen perform in-apartment repairs as well as general building repairs. Noonan proved himself very capable, and the handyman often requested that Noonan be assigned to help them. According to those he worked with, he was eager to help out and had an aptitude for mechanics. Noonan attended the union's trade school at night to improve his plumbing and electrical and general mechanical skills. He also took advanced courses in mechanical engineering and obtained his operating engineer's license. He is presently attending Wagner Community College, taking an associate degree in property management. When an opening for a handyman occurred at the complex in May of 2000, Noonan applied for the post and was promoted. He was advised by Empire that he was selected because of his superior technical ability, his overall attitude, his willingness to work with management. His supervisor, Webb, was so impressed that he promoted Noonan over 2 other applicants who had more time on the job, but who had neither shown themselves to be as cooperative with management nor as skilled mechanically. The collective bargaining agreement under which they work calls for seniority to be considered in hiring and promotion, but makes it clear that seniority does not control.
Webb, as superintendent, had overall responsibility for the day-to-day running of Bushwood Towers. He reports to the managing agent, Elihu Smales, at Empire. Webb, as superintendent, is required to ensure that all employees report to work are on time and are properly uniformed. Webb is also responsible for ensuring that all building mechanical systems are operational, the buildings and groundings are cleaned and cared for, and the repairs are completed quickly and properly. Webb has authority to hire outside contractors such as plumbers and electricians and to purchase all needed supplies, including uniforms, for the efficient operation of Bushwood Towers. Webb also has authority to use independent judgment on behalf of Empire Properties to hire, fire, promote, suspend, assign, reward, discharge, and discipline employees. Webb has the responsibility to direct employees in their work as well as to resolve issues, mediate conflicts between staff, and respond to and resolve grievances. He is on call 24 hours a day, 7 days a week for emergencies and carries a cell phone supplied and paid for by Empire to ensure his availability. Empire also provides Webb with an apartment for Webb's sole and exclusive use. Though Webb is always on call, his normal shift is Monday to Friday, 8 a.m. to 5 p.m. However, during the past 24 months, he has taken off every Wednesday afternoon, 1 to 5 p.m., to attend classes at Wagner Law School. During this Wednesday afternoon time period, Noonan assumed Webb's duties. Webb is also in his final semester and has tendered his resignation to Empire. According to Webb's affidavit, Webb found Noonan to be an excellent employee. Noonan was always on time, efficient and professional, and was always cooperative with management. If asked to stay and cover for someone out sick, Noonan always obliged, though he never himself took a sick day. Webb wrote that Noonan was seen by many employees as, after me, the guy to call on for a work-related problem. If another handyman had a mechanical issue he could not solve, or if a porter needed help with something, they felt that Noonan was the guy to go to. Webb indicated that he started to refer to Noonan as the assistant superintendent. All of the building staff wore Empire-supplied uniforms. Noonan's uniform, at the request of Webb, said Danny Noonan, assistant superintendent. Noonan was also identified as assistant superintendent on the annual holiday gratuity list, which was provided to tenants so they could help tip staff if they so desired. Noonan worked a regular Monday to Friday, 8 a.m. to 5 p.m. shift and was normally off on weekends. His comings and goings, like those of other employees, were recorded by his punching a time clock when he arrived and left work, as well as when he went to and returned from lunch. He was paid the senior handyman hourly rate of $23.50 and time and a half for overtime work.
Noonan's primary responsibilities was that of a senior handyman, but he also assisted Webb in managing the 59 other employees. At Webb's request, Noonan kept an eye on things, helped respond to staff issues, and reported to Webb any issues he felt Webb should know about. Noonan checked the workshops and supply rooms daily and advised Webb on shortages of materials. Shortly after Noonan began to be treated by Webb as assistant, Webb arranged for Noonan to be issued a cell phone so that he too could be called in emergencies. Noonan was the only employee other than Webb supplied with such a phone. If Noonan was called in, he was paid a minimum of 4 hours overtime. In 2006, Noonan, at Webb's request, pre-interviewed 14 candidates who applied for a position as a doorman at Bushwood Towers, using guidelines set by Webb to rate them. Noonan was given a list of general questions to ask and was told to note other factors, such as whether the applicant showed up on time, wore a shirt and tie, was well groomed, had any visible piercings or body art, or any other information about appearance. The interview sheet also contained a section at the end for Noonan to give his general opinion and a box to answer a simple question, yes or no. Would you hire this applicant? When filling in for Webb, Noonan assigned other employees to handle various tasks around the complex. When determining assignments, Noonan evaluated the employee's technical skill and capacity to handle that job, and since working on a repair in someone's home required interpersonal skills as well as mechanical. Noonan also evaluated the employee's ability to work with the particular tenant requiring assistance. During this time, Noonan was rarely free to perform any handyman duties and functioned almost entirely in a supervisory capacity, even though with limited authority. Noonan also handled any serious disciplinary issues or rule infractions requiring immediate attention, such as altercations between staff or between staff and tenants, or violations of safety rules. Noonan reported in writing to Webb any serious disciplinary issues or rule infractions. All of Noonan's reports were placed in the reported employee's permanent record. Webb, on a case-by-case basis, then decided whether to follow up with actual disciplinary action. It should be noted that according to the testimony in the record, all employees were encouraged to verbally report any and all unsafe work conditions or work practices by co-workers. This could be done anonymously. The custom in the building management industry is to use a progressive disciplinary system.
While Webb normally decided disciplinary issues, Noonan on one occasion sent an employee, Carl Spackler, home when he appeared for his shift under the influence of alcohol. The next day, after consulting Noonan, Webb suspended Spackler for an additional day without pay, 2 total unpaid days. On another occasion, Noonan found a porter, Al Zervik, asleep in a supply closet and reported the incident to Webb the next day. Webb suspended Zervik for 2 days without pay. On yet another occasion, Noonan took it upon himself to let an employee, Lou Loomis, leave 3 hours early when Loomis received a call that his child had been hurt at school. The next day, Noonan reported his actions to Webb, who approved his action. Noonan had also approved overtime for 2 porters to stay on duty to clear snow from the walkways after a blizzard. The next day, Noonan reported this action to Webb, who agreed that Noonan had made the correct decision in the matter. Noonan's reports were read only by Webb, who incorporated Noonan's observations along with his own in his year-end report to Empire on all employees. Empire uses these reports to decide the amount of the employee's year-end bonus. The CBA is silent on bonuses, but Empire uses them to reward productive staff. Bonuses are based on 5 criteria: productivity, cooperation with management, attendance, disciplinary issues that year, and comments from tenants. An employee who receives positive ratings on these criteria can receive up to 3 weeks' pay as a year-end bonus. Each employee, including Noonan, is considered for these bonuses. On June 6, 2007, Noonan suffered a serious permanent injury when he was knocked from his motorbike on the way home from work by a drunken driver. The injury was a compound comminuted fracture of his humerus of his right arm, and while Noonan can still work, his capacity to fully undertake the tasks required of a handyman is severely and permanently limited by the injury. At times, Empire requires its handymen to lift and remove heavy pumps and motors from their mounting brackets, help porters carry heavy bags of garbage, and shovel snow. Noonan's doctors have provided documentation that Noonan cannot lift more than 25 pounds or undertake certain other strenuous activities, such as shoveling snow, without serious risk of further injury. On October 24, 2007, Webb tendered his resignation effective December 31, 2007. A week earlier, Webb, by memo, recommended to Empire that they formally create a new position of assistant superintendent for properties with 400 or more apartments. He noted that his having had Noonan to act as his assistant greatly improved service to and satisfaction of the tenants, reduced the number of emergencies by increasing the effectiveness of preventative maintenance, and freed him to concentrate on other important matters. He noted that given the bonus structure for senior handymen, this position might even save Empire money, at least in the short run.
On November 10, 2007, Empire posted a job announcement for 3 assistant superintendents, 1 in each of their 3 largest complexes, including Bushwood Towers. The announcement stated that in the future, superintendent openings would be treated as promotional position and that assistant superintendents already working for Empire would be given first consideration. The base rate specified in the announcement was almost precisely the amount Noonan had earned, including his bonuses, in the previous 2 full years he had acted as backup assistant for Webb. Empire's job description indicates that assistant superintendents will, under the general supervision of the superintendent, assign work, respond to employee requests for shift changes, approve overtime in emergencies, discipline employees in case of egregious conduct and violations of standing orders or safety codes. Assistant superintendents will not have the authority to hire or fire employees or negotiate with suppliers or outside contractors, but will be able to order supplies from approved suppliers and call in approved outside contractors if needed in the absence of the superintendent. They will have general authority, subject to review, to run the complex in the absence of the super. Qualifications for the position include in-depth knowledge of the operations and workings of a large property, ability to work effectively and supervise employees, ability to productively and cooperatively handle tenant requests and complaints, and willingness and ability to respond to emergencies more or less round the clock. The job announcement indicated that assistant supers will not normally be expected to undertake repairs hands-on, but will be expected to oversee all repairs and assist with hands-on in an emergency. On September 18, 2007, Webb informed Noonan in confidence of his intention to resign and of his recommendation to create the new position. Noonan, who had obtained from his doctor clearance to return to work with the understanding he could not perform heavy lifting, contacted Empire to set up a meeting concerning his desire to return to work as the Bushwood Assistant Superintendent. Managing Agent Smales informed Noonan that he was welcome to apply for the official position when it was formally posted, but would be given no edge simply because he had been Webb's water boy and got himself hurt fooling around on that bike of his. Noonan immediately sought help from the union, which contacted Smales to set up a meeting concerning Noonan's union and ADA rights. Smales told the union representative, Sandy McFiddish, that since Noonan had decided to act like management these past couple of years, he couldn't now go running to the union and would have to represent himself. Smales refused to meet with the union concerning Noonan and called Noonan to tell him to apply like anyone else and don't bother me with this ADA nonsense. It's a new position and you've no automatic right to it.
Empire does not dispute that Noonan has a qualified disability under the Americans with Disabilities Act, nor does it dispute that Noonan is unable to perform many of the tasks required of a handyman and that it would not now place him in that position. Empire admits that Noonan is physically able and qualified to handle the responsibilities of assistant superintendent, but concedes that the ADA does not require that it accommodate Noonan by assigning him to the newly created position. Empire contends Noonan is only entitled to be considered for the post on the same basis as other applicants, one of whom may ultimately be found superior to Noonan. Empire further contends that Noonan is not entitled to union representation because when he sought representation, he had been acting as a supervisor for some time, as defined in Section 211 of the National Labor Relations Act. It argues that, as a de facto supervisor, Noonan is statutorily barred from joining a union.
It's my pleasure to introduce the 33rd Annual Robert F. Wagner Labor and Employment Moot Court Competition finalists. Arguing for petitioner, Team 10, Loyola University, Chicago. Arguing the first issue, the National Labor Relations Act issue, is Matthew Dolan. Arguing the second issue, the Americans with Disabilities Act, is Isabel Lazar. Arguing for respondent, Team 5, Northern Kentucky University, Chase College of Law. The first issue, Benjamin Lewis. And the second issue, Sarah Cottle.
Oh, where's my list of who's going first? Actually, you should know who's going first. We're ready.
Chief Justice, Your Honors, and may it please the Court. My name is Matthew Dolan, and I, along with my co-counsel, Isabel Lazar, represent the petitioner, Daniel Noonan. At this time, we respectfully request 2 minutes for rebuttal time.
Very well.
Thank you, Your Honor. There are two issues before the Court today. The first issue, which I will be addressing, is the National Labor Relations Act issue. The second issue, with respect to the Americans with Disabilities Act, will be addressed by my co-counsel, Ms. Lazar. Moving to the first issue. Petitioner respectfully requests that this court overturn the 13th Circuit decision upholding the National Labor Relations Board's determination for the following 3 reasons. First and foremost, Mr. Daniel Noonan was not a supervisor under Section 2 of the National Labor Relations Act, but was a senior handyman who made a senior handyman's wage. Secondly, as was the...
Now, it's nice for you to say that, but if you look at the fact pattern, doesn't he have a supervisory role here? Doesn't he have the opportunity to tell people they're drunk at home, for instance, but a whole series of other obligations that he took over from his boss that make him sound to me like a supervisor?
Well, Your Honor, no, because he did not exhibit the independent judgment required to sufficiently classify him as a supervisor. As the National Labor Relations Board held in Croft Metals, Inc., in situations where an individual exhibits common sense decision-making, he is more of a lead man, if you will, a middleman, a foreman, someone who simply is in between supervisory individuals and who helps carry out their initiatives. In this instance,
what about his judgments that he had to make when he was assigning people to certain tenants to do certain jobs, to work together with other people? Didn't those require judgment about those individuals and their abilities and their personalities that aren't just checklist judgments?
Well, Your Honor, they were not beyond that which is routine and clerical in this sense that already there were porters, handymen, electricians, and so forth. They already had their classifications. They already had their shifts. And what he did, what Mr. Noonan did as a lead man, is he would simply respond to, for instance, a need to fix a boiler, and he would send someone who was qualified to do that. Or if there was an electrical problem, he would find an electrician that was available.
Yeah, but wouldn't he make a decision as to who was the better person to get along with the tenant, which is essentially the help he was providing to management in a supervisory type role?
Yes, Your Honor, there was some assessment indicated in the record that he did take into account the personal traits of the individual and how they may react with respect to taking on assignments and so forth. However, as the National Labor Relations Board correctly held in Oakwood Healthcare, Inc., when it comes to simple tasks, such as, in that instance, it was charge nurses, rotating charge nurses who were telling individuals, for instance, to bring someone a bedpan, to go bring someone water, who is having the best rapport with this patient, who would be best suited to help that patient. And those situations were held by the board correctly, not to be...
Well, didn't the board below hold that he was a supervisor?
Yes.
Don't we owe some deference to that judgment? The same board that made the decision you're relying on decided that he met the test, right?
Certainly, Your Honor, there is deference owed to the National Labor Relations Board. However, as the D.C.
How much deference?
Well, Your Honor, it is in our opinion that the D.C. Circuit in the case of Titanium Metals Corporation put it well when they said that this court is not a rubber stamp, that deference does not mean rubber stamp, that in a sense the buck does stop here, and that this court has the authority, as it has exhibited time and time again in Kentucky River and in Allentown Mac Sales and Service, to step in instances where the board errs in such a way that their determination is contrary and inconsistent to the act itself. Similar to Allentown Mac, in Allentown Mac, that was a situation where the court went in and determined that the individual decision was so erroneous that the determination with respect to polling for union support, that in that instance the board had found that there was no rational good faith basis for the employer in that case to believe that there was a lack of support for the union. And the court got very specific. And the court said that knowing that 7 of the 32 individuals in the bargaining unit opposed that decision was enough to give them good faith basis. So there's certainly...
if we overturn the board's finding, what factors do you think we should consider?
With regard to this specific case, Your Honor? Yes, well, certainly a few things. First of all, this is an individual who was never formally changed, or his status, that is to say, never formally changed. It is reasonable to conclude based on the record that his pay stub still said senior handyman. It is reasonable to conclude based on the record that he still paid his union dues because the union seeks to represent him. He believed himself to be a senior handyman. The vast majority of his tasks, 90% of his week, he acted as a senior handyman. He simply obliged his supervisor's request to fill in informally for 4 hours a week. And for that, they would have him stripped of his rights to collective bargaining guaranteed under the National Labor Relations Act.
Isn't 4 hours a week enough?
No, Your Honor, it is not. And
why not?
It is not in this instance. Well, first of all, the board has indicated that 10% is sufficient, as they did in Archer Mills.
And this was 10%, right?
Yes. However, Your Honor, our contention is that that is an arbitrary number. because there was no explanation in Archer Mills as to why 10% is better than 9 or 11 or 12. It seems to be an arbitrary round number that was picked by the board.
Didn't the board in Oakwood, though, specifically endorse that as a minimum amount of time?
Your Honor, that's true, but our position is that there was a mistake in Archer Mills and that there was a mistake in this instance.
Who has the burden of proof in this case, would you tell us?
Initially, Your Honor, as reflected in Kentucky River, the individual seeking to classify Mr. Noonan as a supervisor, that is Empire, they have the burden of establishing that. If I may, Your Honors, moving to my third point, with respect to the policy ramifications of this decision, if the board's determination is to stand, it will surely send a chilling effect, not only to employees with respect to their rights to collective bargaining, but will send a chilling effect with respect to management efficiency. Simply put, individuals such as Noonan, who were team players, who willingly cooperated with management, the lesson that they take away from this is don't help management. There is an adversarial relationship there, and if you cross the line, if you agree to tell someone to sweep up, or you agree to keep an eye on things and send home an intoxicated worker who is endangering everyone at the site, you could be stripped of your collective bargaining rights. That's not just bad for employees, Your Honors. That's bad for employers.
Is that a question for Congress, though? I mean, Congress wrote this definition. The board has now consistently applied it with, even in this case, and you're asking us to now overturn this on a policy basis that's not really the court's, not the court's duty to judge things on a policy basis. Isn't that a congressional call?
Well, to the contrary, Your Honor, because if we look to the congressional record leading up to the Taft-Hartley amendments, which were passed by Congress in 1947, which included this supervisory exclusion, they used language such as this. They stated that individuals who had abandoned their union, who had gone on to greener pastures, if you will, these are the individuals who have taken on the corner office. These individuals have given something up. They have given up the protection of their union in exchange for something. And the language of the statute implicit in that is an exchange, a give and a take. And here, all Mr. Noonan got was a name tag and a cell phone. And for that, the respondent would strip him of his rights guaranteed under the National Labor Relations Act.
So you are,
Mr. Dollins.
go ahead. Are you arguing that that the policy is inconsistent, that the board's decision is inconsistent with the underlying policy goals of the National Labor Relations Act?
Yes, Your Honor. The goals that are reflected in the Act itself, yes.
And what are they?
Again, there is a balancing act that is conducted by the board. That certainly is true. There are employee interests and there are employer interests, and we certainly concede that. However, what the court was, or pardon me, what Congress was concerned about was individuals who would genuinely rise up the ranks of an organization and take on these greater benefits, be they financial or otherwise, all of which were absent here, take on these benefits, and in exchange for those benefits, they would have to give up something because it was not fair to the employer that someone be protected by the union and simultaneously be a genuine supervisor, genuinely a member of management. But that is not the case here, Your Honor. That's why, although the board did not explicitly state, we hereby expand the term supervisor, in effect, by setting the bar so low, they endanger the rights of thousands, perhaps millions of American workers who are guilty only of helping out their employers when asked to do so.
I mean, I don't understand. I mean, this is not a Horatio Alger world. These people come to work, and in fact, they work hard, and nobody is saying that they're going to be fired, and nobody is saying they're not going to be promoted. All we're doing, if we maintain this rule from below, is saying that these are supervisors, and supervisors don't qualify. I mean, I'm not sure the policy argument holds water. I don't see thousands or millions of men and women out of work because they aren't moving up the pole of management into a management role.
Well, Your Honor, first of all, it is not our contention that they would lose their jobs, but they would lose their collective bargaining rights.
Right. No, that's what I'm talking about.
Oh,
Mr. Noonan, could Mr. Noonan have voluntarily opted out of the union by taking a management job?
Your Honor,
if there's a management job available and he chose it, he could have opted out of the union by taking that job.
if there was a position that was clearly supervisory,
and in fact, that's what he would like to do at the conclusion of this litigation, is take that management job on, called assistant supervisor?
Well, two things to that, Your Honor. First of all, it is our position that that is not a management, or pardon me, not a supervisory position under the National Labor Relations Act, because it's simply turning a part-time lead man position into a full-time lead man position.
And so, by your understanding, could the company define what a management position was in a way that would take it out of the protections of the union?
I'm sorry, Your Honor. I'm afraid I don't quite understand.
What does the company have to do to turn that into a management position, in your view, that they're not doing right now?
I see. Yes, Your Honor. Well, because there is a three-pronged test, as this Court has recognized in Kentucky River, that one, engage in one of the 12 activities listed. Here, the ones that are being contended are assigning and effectively recommending and disciplining.
And when you use the word effectively recommending, that's different than a formal assigned set of duties. Would you agree that the word effectively modifies all of those things?
With respect to recommending? Yes, effectively recommending. However, in this...
And how would you know whether someone's effectively recommending something? Wouldn't it be that their advice was followed by those who were in positions of power?
Yes, that is followed, and also that the recommendation is sufficiently specific that it truly is a recommendation. For instance, in this instance, we have a situation with the pre-interviewing process where there were specific guidelines given to Mr. Noonan. He was asked, does this person show up on time? Do they speak fluent English? Do they seem well-dressed? And then at the end they asked, would you hire this person? And he checked yes on several of those individuals. And then they went into a new pool. And Mr. Webb, the real superintendent, the only supervisor in this situation, would then independently take the people that had been filtered out and make his own decision.
And with due deference to your view of how these facts are to be read, the board concluded differently. And going back to my colleague's character, it's not a rubber stamp for someone to disagree with you, is it?
I'm sorry, it's not
a rubber stamping of opinion of the board for someone to disagree with your view of what those facts are.
That is certainly true, Your Honor. I was simply trying to point out that there are limits, as I'm sure that Your Honors would agree, there are limits to that deference.
Well, and I guess we want to tease out what those limits are. Your argument was that if this court were to affirm, it would create all sorts of incentives that would undermine a union workforce and take away the rights of various people. And I guess that links up to my earlier question, which is Mr. Noonan is perfectly happy if he can get into that supervisor's job to give up those union rights, isn't he?
Well, 2 points, Your Honor. Again, we can strongly state that we believe that this is not a supervisory position. However, if the court were to find to the contrary, it is not, simply because someone has a desire to someday be a supervisor does not make them a supervisor. That is no indication.
In what material way was the formal position different than the one that he was informally occupying?
It was different in that he would have the formal title, so presumably on his pay stub, in the future on his resume he could put assistant superintendent.
Uniform.
Yes, there was a uniform, a name tag that he had. However, again, he was never formally removed out of the collective bargaining agreement. Yes, Your Honor.
Well, you're not suggesting that the court should get into some kind of an analysis as to, well, is he getting enough money? Does he have enough new good things in his job to make him a supervisor? The statutory test doesn't look at anything like that, does it?
Well, Your Honor, implicit in the language, and again reflected in the congressional record, is that there was a concern that individuals who did gain gave something up. But it is contrary. Common sense dictates that it's contrary to the intent of the Taft-Hartley amendments to exclude individuals such as Noonan who gained nothing but a name tag and a cell phone, and for that they
well,
gave
he gained some authority, didn't he?
He gained authority only insofar as a foreman would gain authority. He was the individual who also, it's important to remember, Superintendent Webb was always on call. And if there had come up a situation that was beyond common sense, that wasn't the sort of situation where an individual's intoxicated or an individual's child had a health emergency, those situations he could clearly handle because they were common sense. But
Mr. Dolan, you know the phrase chain of command?
Yes, Your Honor.
Well, there's a supervisor, and then there's a supervisor, and a supervisor. Somebody along the line is going to have that common sense judgment that's going to be second guessed by a boss someplace up the line.
Yes.
Would you suggest then that the only person who actually is a supervisor is the ultimate CEO?
Your Honor, I see my time has expired. If I may briefly answer your question. Certainly, you're correct, Your Honor, that there are supervisors can have supervisors. However, in this instance, there is no sign that he was to be held accountable for those decisions. The person who was held accountable was Superintendent Webb, and he was the one who was trusted to really make these decisions. That's why he was the supervisor. Thank you, Your Honor.
Thank you, counsel.
Good afternoon, Mr. Chief Justice, Your Honors, and may it please the Court. My name is Isabel Lazar, and I too represent the petitioner, Daniel Noonan. As my co-counsel indicated during my time before the Court, I will address the Americans with Disabilities Act issue. Your Honors, this is a case about an excellent, loyal employee whose hard work led to the creation of 3 new assistant superintendent positions, the same position that Empire did not reassign Noonan to after he became disabled and could no longer perform his job.
Let me ask you a question. Is it your position that this new position that they want to create is still a position within the bargaining unit? Is that Is it your position?
Your Honor, the record reflects that Empire and the union are currently at odds in negotiating as to whether or not it's within the bargaining unit, but our position is that the essential job functions of the assistant superintendent, the newly created position, is that of an employee and not a supervisor.
And not a supervisor?
Yes, Your Honor.
Now, let me ask you this. In the collective bargaining agreement, it states that in filling vacancies or newly created positions in the bargaining unit, preference shall be given to seniority order to employees already employed in the building, but seniority shall not control as training, ability, efficiency, appearance, personality, and attitude will also be considered. Is that inconsistent with the company's duty under the ADA as you understand it?
No, Your Honor, because while our position is that the assistant superintendent position should be in the bargaining unit, at the time that Noonan requested to be reassigned, it was not within the bargaining unit. And as this Court noted in U.S. Airways versus Barnett, the collective bargaining agreement seniority policies lead coworkers and other employees to expect fair and uniform treatment. And here, first, that policy was not consistently followed by Empire, even within the bargaining unit.
But won't your position, which is, as I understand it, that as a result of his disability, Mr. Noonan is entitled to this vacancy over all other candidates, doesn't that place an additional factor that's not recognized in the collective bargaining agreement and potentially put the collective bargaining agreement that the union agreed to with the employer at odds with what the ADA says? And if well, I'll let you answer that question.
No, Your Honor, because even if Empire considered their policy in terms of filling vacant positions, Noonan met the criteria. And just because seniority was a policy that Empire considered, it is clear from the record that seniority did not control.
Right.
They also considered individuals with good attitude towards management, which Noonan had in this case, individuals who were qualified. And it is important to note that not only was Noonan minimally qualified for this position, but he exceeded the qualifications that Empire itself articulated in response to what Noonan did as an assistant superintendent before this position was created.
Well, I don't want to beat a dead horse, but if I'm the company and I'm looking at this and I say, I want to consider efficiency, appearance, personality, and attitude, and aren't you saying, no, you can only consider the fact that Mr. Noonan is a protected individual under the ADA?
Your Honor, as this Court noted in U.S. Airways versus Barnett, a collective bargaining agreement is certainly something that an employer can consider, and it creates a presumption that an individual is not automatically entitled to be reassigned. However, that presumption is rebuttable if the employee can show special circumstances, which Noonan can show here. Before we get to that point, Your Honors, we respectfully request that this Court affirm the 13th Circuit's decision and find that the ADA does require absolute automatic reassignment for qualified individuals for the following three reasons. First, it is consistent with the plain language of the statute and with the Equal Employment Opportunity Commission's guidelines. And second, Empire violated the ADA because they did not provide a reasonable accommodation and cannot articulate a single undue burden. And finally, Your Honors, public policy dictates that individuals such as Noonan should receive protection under the ADA.
Doesn't that constitute affirmative action with a vengeance? I'm sorry. Maybe my asking that question is with a vengeance. I don't know. No, but doesn't this amount to affirmative action with a vengeance? Your position, if we take it out to its logical conclusion?
No, Your Honor. Reassignment as a reasonable accommodation removes the barriers that to equal opportunity that a specific plaintiff faces, whereas affirmative action is a class-based remedy that does not require an individualized assessment. And while the ADA in this specific rule may require some preferential treatment, as this Court recognized in U.S. Airways versus Barnett, in order to abide by the equal opportunity goals of the ADA, sometimes an employer must prefer an individual because of his or her disability. And further, the accommodation process by itself, inherent in the ADA, requires some different or preferential treatment because an individual is treated differently on account of his or her disability.
Ms. Lazar, is it your position that the word qualified has one meaning? Now, I'm trying to figure out what you mean by the word qualified. Let's say there were three candidates. One of them was an A candidate, one was a B candidate, and one was a C candidate. Are they all qualified?
Your Honor, if one of those individuals was disabled...
I want to just know, are they all qualified first?
Your Honor, if they meet the specific criteria that the company sets forth and exceed those qualifications and further, as in this case, meet the preferred credentials that Empire ideally sought out for this position, then they are clearly qualified.
Okay, they're qualified. Now we get beyond qualified and we say, can you make a judgment as to which is the best qualified? Is the employer, under your view of the law, required to take a less qualified employee and put them into a position that a better qualified employee who they would rather hire will now lose the job? Is that your position?
No, Your Honor, because first, the reassignment provision refers specifically to individuals who are already employed within the organization.
And suppose there's another one right down the street, old Bob down the street, who works at the company, and Bob's got a great personality, is terrific with people, is vibrant, can do all sorts of interesting things, and just on balance is just better than Mr. Noonan at doing the job. They can't hire Bob down the street?
No, Your Honor, because it would frustrate the purpose of the ADA. The
What
reassignment...
about the purposes of running their business and the purposes of effectively serving their customers who live in those buildings?
Your
They
Honor,
decided there was someone who was better qualified to do that. You're telling us that we should read the law to make the company, obligate the company to hire the less qualified person.
No, because an employer can certainly show that that would create an undue hardship. And an employer can point to an individual who is superbly qualified, that if they do not hire that individual, it would somehow cost the...
And isn't that really what they've asked for in this case, was they put Noonan into the pool, say, well, consider him, but we'd like to see who the other candidates are before we make a decision that he's the guy that gets the job. What's wrong with that?
Because, Your Honor, Empire cannot articulate a single undue burden in this case.
Well, they haven't seen the other candidates yet. How do they know?
Your Honor, as reflected on page 28 of the record, Empire was accepting applications for this position until November 30th of 2008. Noonan requested to be reassigned on October 26, 2007. And when he requested to be reassigned, he requested to meet with Empire on 2 separate occasions, and Empire refused in each instance.
Well, they have an obligation to have interviewed him, and indeed, weren't there other employees that had applied as well as Noonan?
No, Your Honor, because the announcement had not been formally posted when Noonan requested to be reassigned.
But when it was, didn't other employees ask for that job too?
The record does not state that any other employee applied, Your Honor.
So what you're saying really is that one of your major arguments is that because they didn't respond to his request for an interview, he gets the job?
No, Your Honor. It's because the supplemental regulations to the ADA, specifically 29 CFR 1630.2, contemplate an interactive process where an employer and employee must engage in good faith in this dialogue to determine whether or not the accommodation sought out by the employee is reasonable and whether or not it would create an undue hardship.
Is that a question of fact, Ms. Lazaro, as to whether or not they've engaged in good faith negotiating over this position? And again, I'm not trying to quibble. Maybe Noonan's the best possible person for this job. Maybe he's the second best or maybe he's the third best, but you're claiming he's qualified. Is it a factual question as to whether or not the process they've been engaged in is sufficiently protective of his rights or not?
It is a factual question, but if there's a bad faith...
So would you be satisfied with a remand from this court on that factual issue before maybe we're not ripe yet for deciding whether or not there's an obligation under the ADA?
No, Your Honor, because it's consistently been found that if an employer does not communicate or respond to an employee's request for an accommodation, then that employer is engaging in bad faith, and that by itself is a violation of the ADA, which is a question of law. And Your Honors, interpreting the reassignment provision to mean that an employer can simply not deny an employee from submitting an application would be inconsistent with the plain language of the statute, as the 10th Circuit noted in Smith v. Midland. Because under Section 121119 of the statute, reassignment to a vacant position does not state that an employer must first consider or only after a consideration of. And further, Your Honors, it would create a redundancy in the statute. Specifically, under Section 12112A, the employer already has an obligation to not discriminate against an employee because of his or her disability. So reading the reassignment provision to simply mean that an employer cannot deny the employee an opportunity to compete with other individuals would be rendering that provision meaningless, and as this Court has consistently held in cases such as Gustafson v. Alloyd and Colati v. Franklin, A provision of a statute should not be interpreted so as to render another provision meaningless, inoperative, or without effect.
Ms. Lazar, would your position be different if we ruled against you on the question of whether or not this is a supervisory position? Let's suppose for 1 second that we determined that this is a supervisory position. Would you agree that there's now a significant difference in skill level or a different kind of skill that's necessary for a supervisor than for a union member?
Your Honor, the question of whether or not an individual is a supervisor under the NLRA is different from whether or not an individual is, or the position is management material in the normal traditional sense of management. And here, our position is that the essential job functions articulated for the new assistant superintendent position do not arise to the level, or do not rise to the level of a supervisor.
But if they did, if they do, does it make any difference in the obligation of, or your statement, the obligation of the company to automatically give the promotion to Mr. Noonan?
Your Honor, an employer is certainly not required to promote an individual as a reasonable accommodation. However, here there would be no change in pay as reflected on page 10 of the record because the compensation would be precisely the same amount that Noonan had earned for the previous 2 years. And there really wouldn't be a change in job duties because Noonan performed the exact job duties that Empire itself listed would be the duties of this newly created position.
Your colleague tells us that the employer has the burden in the NLRA case, a portion of this case. What about the burden in the ADA case? Who has a burden in your case?
Initially, Your Honor, with the interactive process, the employee should notify the employer that he or she is disabled within the meaning of the Act and request an accommodation, which, as this Court noted in U.S. Airways v. Barnett, should appear reasonable on its face, which Noonan did here. Then the burden is on the employer to show that that accommodation would somehow be unreasonable or cause an undue hardship, which Empire has failed. When the burden shifted to Empire, Empire stated that they did not want to be bothered with this ADA nonsense.
I don't think the burden, just for your information, ever shifts. The burden of going forward shifts.
I apologize, Your Honor, I misspoke. It goes to the employer to state that that accommodation would be unreasonable, which in this case Empire did not. And as reflected on pages 11, 26, and 27 of the record, Your Honors, Noonan met the qualifications that Empire set forth. And as reflected on page 12 of the record, Empire would not now place Noonan in the position of senior handyman. And as the EEOC has recognized, as reflected in the congressional record, and as reflected by many circuit courts, reassignment, an employer should reassign a disabled employee if he or she can no longer perform the essential job functions of his or her position. And further, Your Honors, it is important to note that Congress has already set forth sufficient and adequate safeguards so that an employer is not obligated.
Let me get some clarification. You're saying that the employer has two defenses to an accommodation. One is that it's not reasonable, and the other is that it's an undue hardship. Is that right?
I see my time has expired. Chief Justice, may I briefly answer this question? For a normal accommodation, yes. For a reassignment accommodation, there are additional safeguards. For instance, an employer need not bump another employee who's currently filling the position. An employer need not violate a consistently followed seniority policy and several other safeguards that already exist, which implies that the Congress intended reassignment to be automatic, subject to what they felt were sufficient safeguards. If there are no further questions, thank you, Your Honors.
You may proceed.
Mr. Chief Justice, and may it please the Court. My name is Benjamin Lewis, and I, along with my co-counsel Sarah Caudill, represent Respondent Empire Property Management in this matter. Your Honors, I will demonstrate that under the NLRA, Mr. Noonan was a supervisor, and my co-counsel will demonstrate that under the ADA, he was not entitled to reassignment in this case. Accordingly, this Court should affirm the judgment of the 13th Circuit on the NLRA issue and reverse on the ADA issue. Your Honors, the 13th
Counsel, I assume you think we should pay quite a bit of deference to the Board's decision?
Yes, sir.
Let me ask you this. I mean, the Board's been all over the lot here. I mean, they've had twice they've been booted back by the Supreme Court. They finally got a third decision out. We haven't had a chance to obviously rule on that yet. But how much deference do we owe them when they keep answering the same question differently?
Well, as this Court pointed out, Your Honor, in Kentucky River in 2001, On questions of law, the board is entitled to deference to the extent that its decision was rational. Here, it's our opinion that the board's decision and the 13th Circuit's decision were both rational because it was in keeping. Both decisions were in keeping with Kentucky River with respect to the assignments that Mr. Noonan made in this case.
So the fact that they may have had conflicting decisions in the past doesn't make this case less the subject of deference in your view?
Correct, Your Honor, because the board and the 13th Circuit both followed Kentucky River with respect to assignment with independent judgment. It was a rational decision that the board and the 13th Circuit made, and the factual conclusions that both the board and the 13th Circuit came to support the finding that Mr. Noonan assigned, disciplined, and rewarded all with independent judgment in this case, thereby exempting him from the protections of the NLRA here.
Counsel, if we take your position, don't we, in effect, create a third tier, a third category of employee, someone who's neither fish nor fowl, someone who's neither truly management, a supervisor, and someone who doesn't get union protection as well?
No, Your Honor, that would not be the case because Mr. Noonan here was clearly aligned with management, which goes directly to the heart of Section 211, as pointed out in the Senate report promulgated with Section 211 in 1947 that states that the purpose of the supervisory definition is to establish or distinguish two classes of workers, those with genuine management prerogatives, like Mr. Noonan here, and those who are merely rank-and-file employees. There's four facts I'd like to point this Court to that support the 13th Circuit's finding and the Board's finding that Mr. Noonan was aligned with management in this case. Specifically, Mr. Noonan wore a name badge, which indicated he was an assistant superintendent at Bushwood Towers. He also...
Sorry, is that really exercising supervisory prerogatives? I mean, isn't that just a function of being a handyman in the workplace?
It's only one factor, Your Honor, that supports the 13th Circuit and the Board's finding that Mr. Noonan was a supervisor. Most importantly, though, Your Honor, is the fact that Mr. Noonan assigned with independent judgment and also disciplined Empire employees in this case.
And how did he exercise independent judgment? What facts support that position?
Certainly, Your Honor. The record makes clear that when Mr. Noonan made assignments with respect to tasks at Bushwood Towers, he evaluated the skill level necessary to complete the task at Bushwood Towers and also the employee's skill level in order to match certain tasks with certain employees. And in that respect, this case is just like Kentucky River in 2001 and also Oakwood Healthcare, where nurses in both cases exercised independent judgment to assign tasks because they evaluated employee qualifications and also patient acuity in that case.
Is there anything else, though, other than making assignments that demonstrated his performing supervisory responsibilities?
Certainly, Your Honor. Mr. Noonan also effectively recommended discipline in this case because even outside of the 4 hours that he filled in for Mr. Webb, he was evaluating employees and responding to staff issues. And those evaluations in the context of Empire...
Isn't it true that he only recommended discipline, that he didn't actually communicate with Empire or Mr. Schmale, who was the supervisor for the different facilities? Isn't it true that he just communicated with Webb?
That's correct. And Mr. Webb was vested with the authority by Empire to hire, fire, discipline, promote, and transfer employees. So effectively, Mr. Noonan recommended discipline by completing evaluations of other employees and, as indicated on page 7 of the record, advising Mr. Webb of what Mr. Noonan thought that he needed to know. So effectively, Mr. Noonan filtered information, Your Honor, and decided what was passed up the chain of command.
But he didn't make the ultimate decision on discipline, isn't that right?
That is correct, Your Honor. But he did effectively recommend because he alerted Empire management as to what was occurring in the workplace based upon his own independent judgment, which distinguishes this case from others, like Croft Metals, where the employee was simply a conduit of information. Here, Mr. Noonan...
Did anyone from the HR office ever go up to Mr. Noonan and say, hey, you know what, you're a supervisor now, and you're paying all this union dues stuff over there? Stop doing that. You're not part of the collective bargaining unit any longer. I mean, it seems like a pretty bad way to treat your superintendents if you don't save them some money by telling them that they're making an unnecessary expenditure out of their paycheck. It seems to me it's a little inconsistent with your position you're arguing now about the way you actually treated him at the payroll stage and his classifications within your company.
To answer your first question, Your Honor, Mr. Noonan was never advised in any way that he should stop paying his union dues, but Section 211, the supervisor definition, does not require that employee be advised that he or she is acting in a supervisory capacity.
Does that make you guys bad bosses for him? I mean, it seems curious to me that you're not taking the position that this supervisor in your system, and you didn't do anything to help advise your supervisor not to waste his money?
Your Honor, to the extent that Empire appears to be a bad supervisor, that's simply beyond the scope of the determination of whether or not Mr. Noonan was acting in a supervisory capacity under Section 211.
Well, I guess what I'm asking is, can we read in your behavior or in non-behavior a sense that the company itself was still treating him as if he were a member of the collective bargaining unit? And there's no activity that we can see on behalf of the company that suggests they were treating him as a supervisor for purposes of the way it's defined under the National Labor Relations Act.
Respectfully, Your Honor, Mr. Noonan was treated as a supervisor because he was given a cell phone and he was able to be accessed 24/7, unlike the other handymen, to respond to staff issues and also handle emergency functions.
Maybe he was just the snitch in the union, you know, the kind of the management's guy on the union side, and so that's the way they were rewarding him, was to get tattletale on his colleagues.
The evidence in the record, Your Honor, just simply does not support such a finding because Mr. Noonan assigned and disciplined with independent judgment. His presence on or at Bushwood Towers actually prompted other employees to perform better, Your Honor. He was like another supervisor on site, as Mr. Webb indicated in his memo. Furthermore, Your Honors, Mr. Noonan also assigned overtime in this case. He substantially changed other employees' shifts and hours at Empire Property Management and in Bushwood Towers, Your Honors, indicating again that Mr. Noonan was aligned with management in this case and not with the handyman.
Counsel, don't we run the risk here that if we uphold that there's a legitimate chilling effect that might come about, that is to say that some individuals might be less willing to help management with the possibility that, in fact, they'll pay the prices Mr. Noonan may pay here?
No, Your Honor. That is not the case. In fact, the policy actually cuts against petitioners' position in this case because to somehow allow employees bargaining power under the NLRA who exercise independent judgment to assign tasks and discipline would essentially turn control over to the union in the workplace by allowing the union to make determinations of what disciplinary action or recommendations travel up the ladder to decision makers such as Mr. Webb. Furthermore, it would allow the union and its assistant superintendents like Mr. Noonan in this case to effectively recommend assignments because an employee entitled to protection under the NLRA under petitioner standard would effectively be able to make those decisions under union control, not under Mr. Webb's control. And
that wouldn't be illegal if an employer agreed to that, would it?
An employer could certainly agree to that, but in this case, Empire certainly does not, Your Honor. It is Empire's position that obviously Mr. Noonan was a supervisor and aligned with management because of his activities at Bushwood Towers in assigning and disciplining.
You can be aligned with management and not be a supervisor. Isn't that true?
I believe, yes, Your Honor, there's an exception for professionals in some circumstances.
Well, I'm sort of thinking, you know, you have the rank and file working in a union, and there's 20 of them, and 18 of them think the bosses are a bunch of jerks, but 2 of them kind of like their bosses and get along with their bosses and try to help the bosses to make sure the place works. They don't lose their status as being members of the union because they're, quote, aligned with management on those prerogatives, do they?
And isn't that pretty much what happened here?
No, Your Honor. And if I could answer your question first, Mr. Noonan actually was aligned with management, not because he liked management necessarily. We don't have evidence.
The record reflects that he didn't like management at all.
He probably doesn't at this time.
Yeah, for sure.
But more importantly, Your Honor, Congress gave this court 12 factors to consider in determining when an employee is aligned with management. And here, 2 of those factors are clearly met, assignment and discipline, to demonstrate that he was aligned with management, Your Honors. And additionally, there's also evidence in the record to support a finding that other employees regarding...
Let's talk about this 10%. Isn't that real? I mean, I understand that Arthur Mills and Brown support this proposition, but isn't it really just sort of gossamer, arbitrary? No reason why we should follow that 10% is enough rule?
No, Your Honor, there's very good reason to follow that because it's consistent with...
What are the reasons that are other than what some judge thought up?
because it goes to the heart of the purposes behind Section 211, which is to distinguish two classes of workers and allow management to control the workplace. If under petitioner standard 10% is not enough, then effectively that turns control over to the employees over the workplace at least 10% of the time, which would be dangerous, Your Honor.
Mr. Lewis, management has a way to solve that problem, though, don't they? They can always say, by the way, Mr. Noonan, we are now promoting you out of the position you've been occupying for the last several years, and here's your job. You are now called a boss. Here are the good things that come with being a boss. You get a cell phone. You get to fire people, or at least recommend they get fired. We'll tell you get to tell people who they're hired. They can actually define that job in that way. And the 10%, 20%, 100% doesn't make a whole lot of difference at that point when they define the job that way. They didn't choose to do that in this case. And we're left with is essentially trying to divine out of a bunch of fairly complicated facts what it is that the company actually did. And, of course, the company never claimed anything until this particular set of disputes got going. Is that good policy for us to sort of create deep incentives for employers after the fact to redefine someone's job position?
Your Honor, it's our position that it would be bad policy to actually force employers to go through some sort of formal process to recognize or to make clear that employees are acting under management prerogatives or assigning and discipline with independent judgment.
Suppose we said that you need at least 6 of the factors instead of 2 of the factors. I mean, if you can't figure it out from the job position itself, there's no formal definition, and 10% was something some other group of judges thought was a pretty good idea. I'm voting for 7. What's wrong with that? You got to have at least 7 of these 12 factors. Otherwise, you're not going to be treated as a supervisor. How did I get it wrong?
Certainly, Your Honor. For 2 reasons. First of all, the actual definition of supervisor under Section 211 defines those 12 functions with the disjunctive or, requiring only one to be demonstrated by the employer to demonstrate that, in this case, Mr. Noonan was a supervisor. Furthermore, they would be overturning this Court's decision in Kentucky River.
As we can do.
Certainly, this Court could. But again, Your Honor, it would be directly contrary to Congress's intent. Congress did not require or does not require employers to demonstrate even 2. Congress only requires that employers demonstrate that the putative supervisor be vested with the authority to only exercise 1, which in this case, Mr. Noonan exercised at least 2 with independent judgment.
Let me go back to the 10% factor. That's just a factor, right? It's just something the board has said someone could have as little as 10% of his or her time. But isn't that just one of the other factors we can consider here? It's not controlling, is it?
No, Your Honor. It's not necessarily controlling because in Oakwood Health Care...
Not necessarily. I mean, it's either controlling or not controlling. Is it controlling or not controlling?
We'll concede that it's not controlling on this Court. Certainly, no board decision is controlling upon this Court. This Court has adopted the standard review that only rational decisions under Section 211...
But the board didn't treat it as a controlling factor, did it?
The board did not under Oakwood Health Care. That's correct, Your Honor. But several decisions after 1961 in Archer Mills by the board reaffirmed the 10% guideline. Moreover, even if it was 15% or 20%, there's substantial evidence in the record to support both the board's finding and the 13th Circuit's finding that Mr. Noonan was aligned with management because not only did he fill in 4 hours per week, he also kept an eye on things throughout the week.
I want to take you to another, before your time is up, there's a question that I have. If we adopt your position, are we going to chill the bargaining unit's willingness to cooperate with management?
Absolutely not, Your Honor. Bargaining unit will always want to certainly come together and bargain with management for better wages or hours. But the Section 211's definition of supervisor has been around for a long time, since 1947. And to the extent that only one need be shown, one supervisory function, this has not created a chilling effect. I see the amount of time. Mr. Chief Justice, may I briefly conclude?
I think your time is up.
Okay, thank you.
Thank you.
Mr. Chief Justice, and may it please the Court, my name is Sarah Cottle, and I also represent the respondent, Empire Property Management, in this action. Regarding the ADA issue, Empire respectfully requests that this Court reverse the 13th Circuit's judgment requiring a preference to reassignment for 2 reasons. First, the language of the ADA, the legislative history, and this Court's decision in Barnett do not require automatic reassignment.
I know this case arose earlier on, but have you spent any time looking at the amendments that became effective January 1 to the ADA?
Yes, Your Honor, we have reviewed the amendments to the ADA.
And do they affect your argument here?
No, Your Honor, they do not. The purpose of the ADA is to provide employees, disabled employees, with equal employment opportunities, and also to prohibit discrimination against those employees on the basis of their disability. And requiring an automatic preference would not comport with this Act's goals, the ADA, and would actually place a disabled employee in a better position, clearly contravening the equal employment opportunity intent of the ADA. And also, in looking just at the plain language of this particular statute, does not list automatic reassignment as a reasonable accommodation. In fact, the language of the ADA lists reassignment only as an option.
Well, you wouldn't argue, again, it doesn't affect this case, but you wouldn't argue that because of Supreme Court cases, these ADA amendments were enacted by Congress to broaden the scope of ADA. Is that a fair evaluation, the way you look at the amendments?
Well, to look at the amendments, again, just the purpose of the ADA is to provide equal employment opportunities.
So does that come out on your side or your adversary's side?
To provide an equal employment opportunity does come out on the employer's side in this particular instance. Again, providing a preference for automatic reassignment, as the petitioner is requesting in this particular instance, places the disabled individual on a higher ground, which is not an equal employment opportunity. And in looking at the particular plain language, automatic reassignment is not listed. Reassignment in this particular instance, even if this Court does determine that a preference for reassignment is required, would also constitute.
So your position is that in the statute itself, where it says that it's a reasonable accommodation, reassignment to a vacant position doesn't actually mean reassignment to a vacant position? Would that be your argument?
No, Your Honor, it does not. Our argument is not that reassignment is not in the particular language, but that automatic reassignment is not in the particular language.
It's the absence of the word automatic. So the question is, how non-automatic is the reassignment? So I want to push you a little bit on this. When it's said to be an accommodation, suppose the job was identical to the one the guy was currently holding, except they didn't have to lift any heavy stuff. Would they then have to reassign to that vacant job?
Are you referring to the senior handyman position? Your Honor, in that particular instance, if there was a vacant position and if there was no other better qualified applicant for that particular position.
This better qualified thing, is that in the statute that it's a reasonable accommodation only if there's not a better qualified person for the job?
No, Your Honor. The qualification that an employer hire the better qualified applicant for the particular position is not in the statute. However, this Court in Barnett has determined that in looking at legitimate expectations of employees goes directly to whether an accommodation would be reasonable. And in looking at a legitimate disability-neutral policy of hiring only the most qualified applicant would make reassignment an unreasonable accommodation.
So if you've had this lifetime terrific employee of the company who's become disabled, there's a job open in the company that the person is clearly qualified to do, and no one suggests that he's not qualified to do the job. There is a miraculous person sitting someplace out in the ether that's never been identified who might be better at the job. It's your position. The company has the right and the obligation to go spend time out in the ether, keep searching, hold the position vacant for as long as they want to, and then ultimately decide that they don't have to reassign the position to the guy who's been loyal, a good performer, and now because of a disability can't do the job he was currently in, but could do the job that's sitting there vacant in the company. That would be the position?
Well, Your Honor, again, in determining the reasonableness of a particular accommodation, it goes to legitimate employee expectations. Because Empire, in this particular instance, had a policy of hiring the most qualified applicant for the particular position.
The very guy who invented the position that they're now hiring for, who through all of his work over the years that you claim took him out of the bargaining unit because he was so good at being a buddy for management, that guy's not somebody who should be reassigned? That would be the position?
Well, Your Honor, in looking at this particular position, Empire does have this particular policy, and in looking at the rights of other employees that are employed within this particular organization, requiring automatic reassignment in that particular instance would violate those employee legitimate expectations, which this court in Barnett stated would make reassignment an unreasonable accommodation.
If it's not automatic reassignment, what's the standard that we should use and create to when it's okay to say you get the job and when it's not okay to get the job? What would be the rule of law on reassignment that we ought to adopt and give guidance to management in the future? So we'll make up a hypothetical. A guy's in a job, does a pretty good job and gets disabled, and there's another job that comes due in the company that looks somewhat similar to the one that he's been occupying, and now the company wants to know whether they have to reassign the person to the job. What's the rule?
Well, the rule is looking at the particular policies of the employer. If the employer does...
Now we look at all those policies and we group them together, and you get all the candidates lined up, 1, 2, 3, 4, 5, 6, 7, 8, and they choose 4 who doesn't happen to be the disabled person. How do we know whether they violated the law or didn't violate the law?
And looking at if the person was the most qualified particular applicant.
So your rule is the most qualified person. If they're not the most qualified person, then they don't have to fill the position?
If the employer has a policy, as Empire does in this particular instance, of hiring the most qualified person for the particular position, then that would be the particular standard. If an employer did not have a policy, as again, Empire did have a policy in this situation, if they did not, then reassignment to a particular vacant position, which did not require bumping another employee.
Got what you proposed the rule to be. So the next case that comes down the pike, the employer claims, we hired the most qualified person. The disabled person says, I disagree. I'm the most qualified person, and I'm suing you because you didn't fill the position with me, the most qualified person. How will the trial court or the person who's going to hear this dispute know whether or not the employer has followed the law or not?
Well, again, in providing a reasonable accommodation and looking at that employer's policy, as this court has stated in Barnett, one of those employee expectations that would make reassignment an unreasonable accommodation is looking at objective hiring criteria. And here, as the CBA had indicated, when Empire had made certain hiring decisions, it looked at the training, the skill, the ability, and the efficiency that that person performed the job
We'll
with.
assume for a moment that we agree with the petitioners that this is not a supervisory position, but it's just another bargaining unit position. Are you saying that the collective bargaining agreement between the company and the union, which sets out the factors to be considered, is the complete defense here? That's all they need to do is apply these traditional factors, and there will be no finding of discrimination if they apply those straightforwardly?
No, Your Honor, not only that in this particular case, we also have that Empire has a history of hiring only the most qualified applicant for the particular position. Mr. Noonan has even benefited from this particular policy. He was promoted over 2 more senior employees when he applied for the handyman position in May of 2000.
It has to be the most qualified applicant. Are we going to turn the federal courts now into the second guesser of every employer decision about whether the person was most qualified? Won't that clog the courts with all kinds of very fact-based determinations that are been, frankly, better made by employers, not judges who don't run the businesses?
No, Your Honor, it would not. If an employer comports with the particular policies, and again in this case, which is hiring the best qualified person for the particular position, then they are comporting with providing a reasonable accommodation under the ADA.
Ms. Cottle, from our perspective and trying to set forward rules that are going to be able to be managed by companies like your client, isn't the other rule just easier? I mean, if you got a vacant position, the person's qualified for the vacant position, you got to fill first from there. It makes it simple. We're not going to be sitting in litigation for years and years. And if the person proves out is good at the job, keep the job. And if they're not good at the job, get rid of them.
No, Your Honor, it's not an easier rule. In that particular instance, that employer then has to hire just whoever comes along, which could be a minimally qualified person for that particular job. And that would pose an undue hardship on the employer, whereas another apartment complex, again, Bushwood is an apartment complex, in looking at another apartment complex who's hiring the best qualified applicant for that particular position, where respondent would have to employ a minimally qualified, and the record is not clear. Mr. Noonan obviously is an exemplary employee, but the record does not state that there are other applicants in this particular situation. However, even if this court determines that a preference for reassignment is required, Mr. Noonan is not entitled to the assistant superintendent position because it would constitute a promotion. Under the ADA, even if reassignment
Even if it's in the bargaining unit?
Yes, Your Honor. Under the ADA, even if reassignment is chosen as a reasonable accommodation, an employer is not required to promote the particular employee. And in looking at this particular position, Mr. Noonan's senior handyman functions included mechanical and repair work. Specifically, he did some plastering, some plumbing. He performed some in-apartment repairs. However, as Appendix 2 of the record states, the assistant superintendent will assign work, will discipline employees in cases of egregious conduct, will respond to employee requests for shift changes, will order supplies, and will call and approve contractors. These are other duties that he was not performing in his senior handyman position. And also in looking at the pay difference, petitioner contends that there is no pay difference. However, if this court would turn its attention to Appendix 2 of the record, the position specifically states that the base rate for the assistant superintendent position is $1,500 above the current base rate of the handyman position. And also the record is clear that employees are eligible for bonuses. So Mr. Noonan would be earning more money in the assistant superintendent position. And also Mr. Noonan would be performing the assistant superintendent position on a full-time basis. And also this position presents a preference for the next person in line to replace the superintendent. This is clearly not something that Mr. Noonan had in the senior handyman position. He certainly couldn't jump from the senior handyman position to the superintendent position as he could in the assistant.
Let me ask you this. If he has to be qualified to do it, even if it's minimally qualified, what difference does it make that it's a promotion?
Well, the fact that all the cases, all the circuits are in line, also is this Court's opinion in Barnett.
Well, I know what they've held, but why? What difference does it make?
Well, an employer is not required to place a disabled employee on a higher basis than other employees. In fact, an employer is only supposed to consider, if reassignment is a reasonable accommodation, a lateral transfer. But this is not a lateral transfer in this particular instance.
But the language of the statute doesn't say lateral transfer.
No, Your Honor, but the cases have come down on that. The case that...
But why?
Because, again, Your Honor, it places a disabled person, if reassignment is chosen and a promotion is allowed, it places that disabled employee on a higher level. It turns this non-discrimination statute into a discrimination statute.
But can't you turn around and make the opposite argument? If we were to rule for the respondent, and if, in fact, handicapped employees were going to compete with superior qualified non-handicapped employees, isn't that going to lead to massive unemployment amongst handicapped employees throughout the United States?
No, Your Honor, it's not. Again, this is determined on a case-by-case basis, and it would depend on the employer's particular policy. And here, the respondent does have a policy of hiring the most qualified applicant in this particular situation.
When it turns out that, although their policy of hiring is to hire only the very best and most qualified, it turns out that when they actually start working their jobs, some of them are better than others of them. Is it also the company's policy that they keep lopping off the bottom each year, and so we're going to constantly improve our workplace? I'm a little bit troubled by this best-of-breed notion that you're putting forward, because it suggests to us, here's a guy who is doing a perfectly fine job in the very job the company is creating. Nobody had a problem with the way he was working, and now that he's become disabled, all of a sudden he's not qualified enough for the same job. I mean, were I a trial lawyer, I might argue that suggests that there's a discriminatory motive on behalf of a client that will no longer work with somebody who they once thought was just absolutely terrific.
Well, Your Honor...
Is that kind of factual question that somebody's going to want to think about at the trial level?
Well, Your Honor, in looking at this particular instance, Mr. Noonan is an exemplary employee. This is not in dispute in the record, and nor do we dispute it here today. However, in looking at reassignment, the key is, in looking at the reasonableness, is the employee's policy, or is the employer's policy, and that particular policy will instill expectations in other employees, so that if that individual is given an automatic... Mr. Chief Justice, I see that my time has concluded. May I briefly conclude? Thank you. So in giving a preference to a disabled individual, that would undermine employee expectations, which is inconsistent with this court's opinion in Barnett.
I mean, I hate to interrupt you while you're sitting down, but I just have to ask you one other question. What about the employee's expectation that they'll be treated well by their company if they ever had an injury on the workplace or outside the workplace that caused them not to function well at some things, but they would still be pretty good at others? A policy that says to them, tough luck, you're out of luck, that would be good for the employees?
No, Your Honor, and that's not the policy that we're suggesting today. The policy that we are suggesting today is consistent with this court's opinion in Barnett in keeping in mind employee expectations and to provide a reasonable accommodation which is required under the ADA. Thank you.
Thank you. The petitioner reserved 2 minutes.
Yes, Your Honor. Thank you. Your Honor, 3 points on rebuttal. First of all, opposing counsel stated that Mr. Noonan effectively recommended disciplinary action in his exchanges with Superintendent Webb. That is not the case, as he did not recommend specific suspensions, but merely reported what had happened, and Superintendent Webb made his own decision. Secondly, opposing counsel stated that the Act, the National Labor Relations Act, describes 12 activities which indicate being aligned with management. The terms aligned with management do not appear in the Act, and management alignment has nothing to do, or pardon me, is not the same as being a supervisor under the Act. Lastly, opposing counsel stated that there is a $1,500 pay increase from the position of handyman in this instance for the new position. That is true, but insignificant, as Mr. Noonan was not a handyman, but a senior handyman, whose pay scale was well above that of a handyman. Thank you, Your Honors.
I think we retire.
We'll take the case under advisement.
While the justices are sitting and deliberating, we have, we as an association have some thank yous to give out specifically, and 2 members of our e-board who ran the Frisell competition in the fall will be doing that, Tiffany Rex and Love Exter.
Good afternoon, everybody. My name is Lev Exter, and this is my Frisell co-chair, Tiffany Rex, and we've been appointed to speak on behalf of the association and thank some people that might have not gotten the full thanks they deserve. I don't think we'll be as prepared as the impressive oralists were. And I hope everyone gives a little consideration to the fact that last evening there was an open bar at Wagner, so that, but nonetheless, we'll let Tiffany start it off.
Hi, everybody. First, we would just like, on behalf of the association, to thank the amazing jobs that the editors did in preparing the fact pattern and the grading. 46 teams, was it? 45? 46 teams. It's a lot of briefs to be graded. And they did a fabulous job along with the authors in all the work that goes to the written products that you have to do for a competition. So on behalf of the association, thank you to the editors. And on the writing half of the side, I would also like to thank the authors once again. The fact pattern was fantastic. Every single judge in every round absolutely loved it. I mean, it's pretty good if another competition wants to use it. So thank you for all your hard work for so long. I'm sure you never want to hear the name Noonan again in your life. But thank you. We all appreciate it. Thanks for making us look good.
So during the for sale competition, the current Wagner chairs came up here and they had some kind words to say about me and Tiffany. So we've been racking our brains for the last couple weeks trying to find anything kind to say about them. So I'll get started with that. I'm sure everyone at this point is very familiar with Adam Love. Everyone refers to him as Dr. Love for a multitude of reasons. But nonetheless, he did, I think we could all agree, did a fantastic job playing this competition, from getting a lot of good judges, the esteemed final round bench. The level of competitiveness is pretty visible from the final round oralists here. And I think there's a reason why there's a year-long wait list to compete in the Wagner competition. And there's a reason why I booked up so fast this year. From the event last night that we had that I mentioned a little earlier at Hudson Terrace. I mean, I think the whole event went off without a hitch, and I think it's because of the selfless work that Jillian and Adam put in, the long days in the office, the long nights that their significant others probably didn't enjoy them spending together, the thousands and thousands of dollars that Adam Love spent at Starbucks. All of it, rolled up into one amazing Wagner competition. So everyone please give them a round of applause.
And then there's Jillian. I know how good this day feels. Definitely enjoy it. It flies by. You did a tremendous job. You're micromanaging, so worth it. I know everything that goes into the competition, and I told you the other day I didn't even feel like there was a competition going on. You just seemed so much calmer than I did, and it went off. It rolled off. I know the gift we got you is going to come much, 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 much in handy, as did the one I got, and I appreciate it. And just enjoy the rest of this day, and thank you for giving us a great, great competition.
So thank you for giving me and Tiffany a moment to speak, and I guess we'll at this point wait for Adam to come up here.
Jill, come up. So now we could go back, pretend that nothing ever happened. We're going to restart the day. Thank you all for coming. We're going to say a few thank yous. So, Sandra, you mean the world to us and our association. We can't begin to thank you. So come on up here. These are for you. You're going to have to watch the webcam for everything else that we thanked you about. We're good. Hang out, have fun. Hopefully, sooner than later, we'll
Get the final winners and stuff.
Woo! one more announcement. Just kidding. Forget it. Scratch that. They got upset. If everybody would please start taking their seats, the judges are going to start entering in a moment. Thank you. Ms. Cotlin to the front. Ms. Cotlin to the front.
Seated. What we have decided should have no effect on the fact that we found all of you to be remarkable. And so far as my court is concerned, I would be delighted to have any of you in front of me. But since we had to make some decisions, we have concluded that Matthew Dolan was the best oralist and that the petitioner had the best team. Take a moment, and then I trust my brethren will have more to say about it, or at least as much. I look at oral arguments. Many people think oral arguments make no difference. That is, the decision is made by the time at least the lukewarm court gets on the bench, and I fancy myself at least lukewarm, almost invariably, sometimes even hot. But I must say that in at least 20% of the cases, I change my mind, or at least have a significant concern about my original thought. What happens is there's the memorandum of law I read, I give them to my clerk who's assigned to that particular motion, and they provide me with a bench memo which generally comes out the way I say it should, but not always. And then we go to the oral argument, which everybody seems to think they ought to have. Well, almost everybody opts for oral argument. And so, in my view, the oral argument has become more and more important over the years, at least to me, and has made me rethink, as recently as last Monday, a decision that I thought I pretty well had or was ready to decide off the bench. In any event, that's just for folklore. The fact is that everybody here, at least so far as I could determine, did just about all the right things. When there was a question, they answered the question, and they didn't say, I'll get to that in a minute, which is sometimes what I hear. They looked at the judges so they didn't fall asleep, or at least they looked at me so I didn't fall asleep. And generally speaking, the way in which they handled the questions and the way in which they performed was all, I thought, quite extraordinary. Those are my large thoughts. You go next.
Well, first of all, I want to congratulate each of you because I think the fact that you have gotten to the final round of the largest tournament that the school has ever held in this area shows that alone indicates what great skill you have and what credit you bring to yourselves and to the institutions you represent. I got to serve 1 year as a sort of judge, as a member of the National Labor Relations Board. One of the things we didn't do was have oral argument, and I think it leaves us poorer because of it. I think oral argument, in agreement with Judge Bear, does, I think, elucidate the issues and brings us to a more sharpening of them. I want to congratulate each of you. To a person, you were obviously very well prepared. No question seemed to throw you, and you were responsive to our questions, not dodging them. There's the old story about some lawyer in the Supreme Court said, well, I'll get to that in a moment, Your Honor, and the judge said, you're there. You didn't do that. You were there, and so I just want to congratulate each of you. It was a very difficult decision, and all of you were excellent.
I just want to congratulate all of the contestants. I thought you did a really excellent job. Over the years, I've been very fortunate to have the opportunity to see many of our appellate courts and to hear many arguments and to argue at all the levels of appellate practice. I think that, as my colleagues have said, oral argument can elucidate arguments for the court and clarify the issues and really bring focus on what's essential to resolving a problem. Matthew, I thought you did an excellent job as lead-off counsel and helped to elucidate, helped to clarify for us the basic issues of your position. I was very impressed with your performance, Isabel, and thought you did an excellent job. Ben, I really loved your argument. You were the contestant of the day, and I thought that you did an excellent job of answering questions and of presenting your position to the court and getting back to the points that you wanted to make. And Sarah, I also thought you did an excellent job. You're the end of the process, and some of the air has gone out of the court, and the court has had a chance to think through the issues by the time the last person gets a chance to argue. But again, you kept bringing us back to the issues that you wanted to impress upon the court, and I thought you did an excellent job. So I just want to congratulate all of the contestants.
I incorporate by reference what my brethren have said so far. And let me just add that you never know when you come out and judge these cases what the bench is going to be like. If it's going to be a hot bench, lukewarm bench. This was a scorching bench. Everybody came out and was firing questions right away, which made your job harder. But none of you flinched, not even once. You were perfectly adept at answering questions, getting back to the arguments you wanted to make. I enjoy doing this. I do this on a pretty regular basis. And everything about it is wonderful except for one thing. And the one thing is the difference between the winning teams and the winning advocates can be measured in millimeters. Unfortunately, one oralist has to be chosen, one team has to be chosen. But it's very difficult when we go back there and we have that discussion, because at this level, everyone is truly at the top of their game. So I want to congratulate all four of you. It was an excellent job. And reassure all four of you that in the long run, no one is going to remember what took place in this room. But what we'll remember instead is how successful you will be, and I have no doubt you will be, in your future legal careers. I hope our paths cross in that context. I know that you will serve your clients well, and you will bring credit to this great profession. Congratulations to the four of you, and thank you for inviting me. I appreciate it very much.
Thank you. Being a great advocate obviously begins with what you've written. We didn't have the benefit of seeing your briefs, but I'm confident, based on what you did orally, that your briefs are just outstanding. And as much as Judge Barrow was telling us oral argument's importance, we also know how important it is that the care and thought that went into the preparation before you ever got here on learning this problem and putting it in writing and helping to hone your thinking as you move forward. Substance, style, wow, right? I mean, at the stage of your career, you've got both of those things going for you. You clearly understood this problem in a very deep way. And as a matter of style, for us to be able to see people as early in your careers as you are, as poised and confident and capable of dealing with what was being thrown at you, you'll rarely have this experience, I think, in the world. Sometimes you'll have benches that are hot, sometimes you'll have benches that have just opened the materials in the morning, but you're always going to be hot. And I think it's comforting to know that as you go forward, you'll have that going for you. What you don't have is context, and I think as you get older and experienced, that's what you will gain that will actually round out what you have going for you as advocates. And my father once told me there's no such thing as a wise young person. He was right. And there's also no such thing as a wise old person who didn't begin as a very hardworking, aspiring person in their field, all of which you have going for you. So I know I speak on behalf of all of us and just admiring your work ethic and the commitment you have. Before I end, because I get to speak last in this, I want to thank again all of you who have come out today. As I look around the room, I'm sure there's some moms and dads and sisters and brothers and significant others. Congratulations to all of you. I know that your lives have been miserable with your kids as they've been working their way in this competition. They will return to some form of normalcy soon thereafter. That could be good, could be bad. I don't know. I'm not going to make a judgment. But thank you all, the parents and significant others in this room. Competitors from other schools, my guess is there are some of you who have stuck around all the way to the bitter end to see what the winning argument looked like, and thank you for staying and supporting your colleagues from other schools in their terrific work. And my sort of final remarks remain for those who are part of our community. To the judges who volunteered their time, I look around the room and I know there are a lot of volunteers who have been out here coming to these arguments. That's courage beyond the call if you stick it through all the way to the end and come to the final argument. And your pay didn't go up, by the way, for doing that. So thank you for sticking to the very end. To our students who have been part of this process and helping to shepherd and host all of the competitors from other schools, I want to thank you again. I know you put on a great competition for the students, make them feel welcome in a city that some people don't necessarily think is welcoming. We, of course, know it's the most welcoming place in the world. And so for all of you who are our guests at the law school and our hosts on and the students and faculty, thank you. And my final thanks go to the people who organized the competition and wrote the problem and their supervisors. So for the two authors, I know you've been kudoed up and down the line. More kudos to the two of you who worked on building the problem. And then to our two chairs and supervisors of this competition, they haven't been sleeping for weeks, and I've been told they're going to actually, at least Adam's taking a day off tomorrow. No classes on Monday, is that the story? No class, got it, okay. Story's sticking to it, and it works out great. Susan Abraham, our advisor, thanks Susan. Carlin, who helped work on the problem. Art Leonard, who's also in our labor program, is a guiding spiritual force for the students in the area. And my colleague Carol Buckler, who's our associate dean. I see the four of you, and I'm not sure there are other faculty members out there, and if you are, I'm sorry if I've missed you. Who else is up there? And Diane. Hey, Diane, you judged also? Fabulous. So thank you, my colleagues, and thanks all of you for your rapt attention during the competition. It's really been a joy for all of us. My guess is there's a picture-taking thing that's going on.